gotten a copy of the grand jury report.
This is your way. Can I stick that right here in the middle?
Actually, look, yeah. Bev, do you have a couple?
Copy.
Look right up there, right up
I got
on my
one.
bin. I think there's some.
Right here, sir.
Yeah, there you go.
No, I need that.
Yeah, just, yeah, here you go.
Thank you.
Yes, scoot over here a little bit. I assume these folks may want to hear from you as well. Look out of the way. They really did not.
Can I close this door?
Absolutely. We're going to have TV. I guess my comments about hit and runs or something must have. You good to go? All right. On March 6th of this year, Mr. Justin Stottlar, who's seated beside me, a recent elected member of the Perkasie Borough Council, called me to advise that after doing some legal inquiring on his own, he had concluded that he may have participated in a meeting which violated the Pennsylvania Sunshine Act. Because this office had shown itself ready to prosecute elected officials like Barbara Riley, Mr. Stottlar was concerned that he not be subject to prosecution for this unknowing violation. I determined that Mr. Stottlar's concerns appeared to have merit and assigned Larry King, a consultant analyst in my office, to meet with Mr. Stottlar. Mr. Stottlar provided Mr. King with a 3-page memorandum, which included a proposed sale of real estate owned by the Borough of Perkasie, upon which is erected an old power generating plant now used as the electric department headquarters. The prospective buyer of that property, Vacubraze, owns property in the immediate vicinity of the electric department and is a substantial consumer of electricity from the borough. Perkasie Borough at one time operated its own generating facility back in the dim, distant past, but has long since given that up, retaining the electric distribution system by which it now distributes electricity purchased from other producers. I'm told that's common with many boroughs, both in Bucks County and elsewhere. Also discussed in the memorandum, which had been prepared by Borough Manager Dan Olpere, was the prospect of selling electricity to Vacubraze at a reduced rate. Immediately below the heading on the memorandum, Mr. Olpere wrote the following: confidential. The following information is confidential and is intended to be discussed in executive session at the next council meeting. Because the majority of the subject deals with a potential real estate transaction, it should be deemed confidential and can appropriately be discussed at an executive session. End of quotation. What Mr. Olpere told his council members is not correct. It is not an accurate statement of the law. Nevertheless, an executive session was indeed held on March 5, 2012 by the Borough Council, at which time both the prospective sale of the real estate and the creation of a reduced electric rate for Vacubraze were the principal topic of discussion. This is not allowed by the Sunshine Law. However, the language of the Sunshine Law authorizes the imposition of penalties only upon the elected members of the Borough Council or other governing body, whatever it might be. Moreover, even those elected officials may only be penalized when they participate in a Sunshine Act violation with the intent and purpose by that member of violating the Sunshine Act. Because the members of Borough Council had every right in good faith to rely upon the words of Mr. Olpere, and because their solicitor was privy to the memorandum and present throughout the proceedings without comment, there was no reason for any of the Borough Council members to believe that they were acting contrary to the law, and certainly no reason for us to believe that they had the intent and purpose to violate the law. However, because of the seriousness of the matters involved and the need to prevent such conduct in the future, my staff and I deemed it appropriate that this matter be submitted to the current investigating grand jury so that we could get at the truth of the matter and so that we could have the benefit of the voice of the community, which our grand jurors represent, in determining an appropriate response to this conduct. After hearing testimony and receiving evidence as described in their report, the grand jury determined to issue a report. In that report, they find that the Sunshine Act was clearly violated by the discussion in executive session of a proposed sale of borough property and the discussion of the establishment of a proposed favorable electric rate for a single business in the borough. However, they concurred with our analysis, and I will say specifically, the buck stops here, my analysis, that the manager's advice in his memorandum constituted a defense to prosecution of any of the borough council members. Accordingly, the grand jury recommended changes to the Sunshine Act itself to prevent a recurrence of situations in which the paid professionals of an elected body can shield elected officials from criminal liability for violating the act by making sure that managers, solicitors, others who would advise on this point have, as the expression goes, skin in the game in the form of their own possible criminal liability. I will be sharing the grand jury's report, which of course I have shared with you folks here today, with legislators from this area and around the state. Of equal importance, it is our hope that this report will serve as a notice to the officials of other Bucks County municipal governments, including school boards, that this office will expend resources where we deem it appropriate to see to it that the Sunshine Act is obeyed by local governments throughout Bucks County, and that those who make the choice to ignore the Sunshine Act will bear the substantial financial consequences authorized by the law. Now, I will be happy, of course, to entertain questions, and I see we've been joined by a couple of people. Bill, do you have a copy of the report? Here.
Thank you.
Yes, sir. Be happy to entertain any questions. However, Mr. Stottlar, do you have anything you wish to say at this point? Okay. Yes, ma'am.
Mr. Heckler, Hillary Bettman with the Intelligencer. A couple of questions for you. You mentioned the financial implications of the violation. What are they?
Well, it used to be just $100 per individual per violation for first offenses. To tell you the truth, I'd have to look at the act. It does ramp up after that if you just keep on violating the law. In response to a Lancaster County case a couple of years ago, the legislature, recognizing that that was a pretty toothless tiger, increased that penalty to up to $1,000. So at the discretion of the judge who would hear this matter, each individual elected official who participates in a violation, a hearing or something that's a violation, can be fined anywhere from $100 to $1,000 for first offense.
For first offense. You mentioned that this report sort of serves as a notice. How pervasive do you believe Sunshine Act violations are in this county?
I don't believe they're pervasive at all. I hear have heard some complaints. There are, frankly, as you may know, and this, I'm not going to turn this into a Jeremiah against the commissioners. These are tight financial times, but we have limited resources, and what we have to prioritize, and murders, rapes, other offenses of that sort obviously take precedence. This was a case that, thanks to Mr. Stottlar's good citizenship, that sort of presented itself, and if you will, landed in our laps. It wasn't too tough to track this down, particularly with the memorandum which was written. There are a few other cases that we are looking into and might conceivably yet yield something in terms of a prosecution. But on the whole, I think there is a natural tendency, and of course right now, times are grouchy. The people don't have money, they are enthusiastic about paying in taxes, and so local governments are under considerable pressure, feel themselves to be under pressure, and it is natural when somebody is tending to want to discuss something that may get into those grouchy areas. They're not foolish. They recognize that it'd be nice to not stir up the public. The Sunshine Law is clear. There are, when you're discussing matters of policy, except for the exceptions that are spelled out in the Act, you've got to do it in public. And we know I've been around government one way or another for a long, long time, and I have always believed that sunshine is the best antiseptic. And so I'm not telling you that I think there have been hundreds of violations. I think it would be, even if I knew, it would be far fewer. And of course the problem is we don't know in a lot of cases. Hopefully this will inspire people on the one hand to come forward because they know we'll be serious, or come forward because they don't want to be on the wrong end of one of these prosecutions. On the other hand, what I'd really like it to do is encourage people to follow the Act to begin with and to bend over backwards. And actually, I've heard a couple of tales already with things being for me, things being sure. By the way, evidently we have the Perkasie Solicitor here. I don't know whether he wants to offer rebuttal. I'm not inclined to get into a debate today, but at any event, we'll let him in. So I don't think this is necessarily a terrible problem, but I want people to know that that we will devote resources to it.
You mentioned that the Sunshine Law is clear, though I don't know from being an observer of other entities and elected officials that they perhaps always understand it, or always understand the breadth and depth of the exceptions. Do you think that there needs to be some more training of elected officials as to what they can and cannot do behind closed doors?
That's never a bad idea, but the municipalities have the opportunity to do training on a regular basis. Heck, if somebody wants me to or my staff to attend, I'd be happy to do that. The township used to address the township officials, and we're in another life, we're in another hat. The Act is pretty simple and straightforward, and in this case, the Borough Manager attempted to justify his actions, and this is detailed in the report, because they were discussing a real estate transaction. Well, that's not what the Act says. The legislature made a clear distinction for their own purposes, and I can see from a policy standpoint why they would, that if you're selling property that's already owned by the taxpayers, that's not a proper subject for an off-the-record meeting. Buying, for the obvious reason that you're in negotiations, you don't want to tip your hand to the other side, is a proper exception. As I say, I'm certainly satisfied that the public officials here weren't on notice. It is notable, and I don't know whether Perkasie's just unlucky, but there was quite a stir about exactly this kind of problem in Perkasie in the early 2000s. Now, that was early enough that none of the people who are presently members of Borough Council or who are members of the staff were actually present, although I think it was called to Mr. Olpere's attention that he he came in the aftermath of that and actually is quoted as commenting in one or two of the news articles from the time. I'm sure you can dig those out, and I have copies if you'd like to at least look at them to get the references. But this issue came up before in Perkasie. There was not a prosecution at that time, but it's not an unheard of problem.
What do you think the chances are that of these recommendations that the grand jury made being implemented?
You know, that's something, and I know something about the legislature. It's really not something I would speculate on. I would hope that some of the forces coming to bear on the legislature in favor of good government in general would have some significant traction. I see today my old roommate Sam Smith, now the Speaker of the House, had proposed that that we reduce the size of the House in Pennsylvania, and that the House passed that piece of legislation. So this may be a time when people would take a good look at this. Yes, sir.
Isn't it the, maybe you addressed this before, Guy, but isn't it the solicitor's responsibility to advise the Borough Council on provisions of the Sunshine Law and what can and cannot, what activity, action can and cannot be taken in private session?
Sure. And it's also, especially when you have a borough manager as experienced as Mr. Olpere, you would not think that he would be giving people advice in the memorandum that says, don't worry about it, this is on the up and up. This is one, I want to be very clear here. If we thought that there was something criminal in the sense that the fix was in, that there was something untoward going on, we wouldn't be sitting here talking. We would still be investigating, and we would ultimately be taking it to the grand jury if that tool was necessary for a much different purpose. There is no thought on my part that this was anything but an innocent mistake on everybody's part. And as I say, we're not prosecuting the members of council who are the only people under the act as it's written who can be prosecuted, because we have every reason to believe they had a good faith belief that they could do what they were doing. But it is equally clear to me, and I think I'm sure we could make copies of the Sunshine Law for you, that there is a significant distinction between selling property that already belongs to the taxpayers and debating or planning to buy other property. And the fact that if you read the detail of the grand jury report, you'll see Mr. Olpere tries to sort of justify, part of what we were talking about was purchasing property. That's not so. That's not so. The report makes it crystal clear that they even analyze a site that is already owned by the borough, presently unimproved, I gather. At any rate, it's a site that the electric facility themselves have earmarked for a while as this is where we'd like to build our new facility. And they're apparently, they went far enough to have the borough engineer do some sort of thumbnail calculations at any rate as to how that would all go. So, the legislation says what it says, and what was being discussed by these folks, number one, wasn't the purchase of real estate, it was the sale or other disposition of real estate. Now Mr. Olpere also sort of tries to make an argument that, well, lease is at least, the use of lease is at least confusing. The grand jury didn't find it so, I don't find it so, frankly, but the other recommendation that we make is, well, if anybody could possibly find it so, when they talk about sale or lease, if legislature, if you intend that, as we think you intend, that anything that disposes of property the public already gets, already owns, should not be the subject of a closed-door session. Why don't you spell that out with clarity so even Mr. Olpere won't be confused about it? All right, I lost the train there, so that's that, Ingrid.
You said innocent on everybody's part, including Mr. Olpere. Was this an innocent mistake on his part? Or is it simply that he cannot be prosecuted under the current law?
He should have known better. Whether he did, I'm not the, what is it, the shadow knows, sees into the hearts of men. I don't know exactly what he knew. I know that I can't prosecute him under the Sunshine Act.
Justin, sitting in that meeting on March 5th, did you realize then that there was something perhaps unkosher going on?
What was going through my head was what could be talked about in executive session under the Sunshine Law. So what I did that evening was I went home and got my Pennsylvania State Association of Boroughs book and got my interpretation that you can only talk about the acquisition of property, not the sale. I contacted the Pennsylvania State Association of Boroughs the following morning, and they agreed that my interpretation of the law was correct, and at that point in time is when I had called Mr. Heckler.
Do you believe that any of your fellow members of council thought something was not right?
Judging by some comments that were made, I do feel that there were some. There are some others that may not have known. But again, our borough manager has a long list of credentials. He speaks on government. He should be well aware of the law, and so should our borough solicitor.
Let me make another observation, and I think it's consistent with the findings of the grand jury. This whole business of the sale and wholesaling of electricity is a little foreign to me, but it's something that is done by a number of our municipalities, obviously quite within the law. It is, and evidently it is the borough governing body, and in the case of a borough, the council, who has the say-so over setting rates and the running of that particular business. It would seem pretty plain to me that a proposal to set rates differentially for one, particularly for one industrial customer, is also a matter that you just can't discuss behind closed doors. And again, we've got plenty of people to prosecute. I can see some preliminary, gee, do you think maybe we ought to set up a differential rate system being sufficiently vague and diffuse that you don't, that doesn't trigger a sunshine violation all by itself. But this involves a fairly specific discussion of doing this for this particular entity, a subject which I don't doubt would cause considerable dispute, debate, whatever, if discussed with the public. I cannot conceive of how that is a proper matter to be, not to be sunshine. And that sort of, we get into the same, well, it's a fine distinction, buying, selling, what the heck. Especially if rates are high and debated, which I gather, a sore subject, which I gather they are in Perkasie. The idea that for whatever purpose, which may be laudable, you're going to cut somebody some slack so that they stay in the borough. That may be a perfectly proper thing to do, but it's inconceivable to me when you look at the definitions of the Sunshine Law that that's not something that needs to be done in public.
Do they have to go back and redo this in public session now, or is it too late? Is the
Well,
genie out of the
well,
bottle?
first of all, there was no final action taken here, so that there's nothing that's voided what all of this amounts to at the end of the day is a shot across the bow. These subjects are now, by virtue of our bringing this to the public attention, they will be publicly debated in Perkasie. And for all I know, we are not releasing the memorandum itself, so we're not pushing the specific details of whatever Perkasie's talking about out into the pages of the newspapers. That's not my business. My business is to see to it that the Sunshine Law is adhered to. And in this case, where it's been violated, but under circumstances which gives rise to some, at least in my view, apparent weaknesses in the law, to pass the word along to the legislature that hey, there are ways we can make this stronger, and that's what we're doing. But for you now, I'm sorry. At the end of a long week, I've lost the question.
You got it.
No.
Is this a solicitor?
Yes, he is.
May I ask you, were you aware of this provision of the Sunshine Law?
Yes, and Mr. Olpere and I conferred, and our interpretation of the law was not the same as the district attorney's, and I will have to review our actions going forward, it seems.
But Mr. Heckler has indicated that it's a fairly clear-cut provision in the Sunshine Law. Are you saying it's not as clear-cut as you would portray?
Having just walked in a few minutes ago, there's a different interpretation of that provision regarding the lease and purchase distinction, and as from what I understand of the press conference, the DA will be making recommendations to the legislature. Beyond that, I can't comment any further.
Can you just give your name, please?
Nathan Fox.
And how long have you been solicitor for the purpose?
Since February.
Of this year?
Correct.
Are you a solicitor for any other municipalities?
Just Perkasie.
Do you work for a law firm?
I do.
Can you tell me about this?
Begley, Carlin, Mandio.
Justin, you're a member of Perkasie First, correct?
Yes.
And there's no hiding that there's been some tensions within the borough, between council members, different philosophies. Electric rates have obviously been a huge issue, which Mr. Heckler alluded to. Some may perceive this as an attempt to stick it to certain members of council and perhaps the administration. Do you have any response?
I don't believe that it's that at all. I started this political action committee because of the electric rates. We had a 66% increase over 2 years. Electric rates are at their all-time lows right now. My understanding from my constituents was they put me into office to put a stop to doings such as the violation of the Sunshine Law. As you heard Mr. Heckler say, it has happened in the past. My constituents want the governing body in Perkasie to be completely transparent with them. So I chalk it up as simply me doing my job.
And just so we're clear, I don't believe Justin misspoke. I don't know of any prior violations of the Sunshine Law. We're in agreement that this was a violation. If there have been others, that's not something that's been brought to my attention. Just so we're clear about that.